Good afternoon, good evening, everyone. Good morning. I welcome you all to the 7th seminar of the International Interdisciplinary PhD in Progress Seminar Series, Phase 4, organized by the Global South Network. I would like to start the session by thanking the organizer of this weekly seminar series, Dr. Nauman Rayat, lecturer in law, Leicester Law School, and who is the founder and the convener of the Global South Network. I am Dr. Tonny Raymond Kirabira. I will be chairing today's session. I'm a lecturer at the Department of Law, Justice and Policing, University of East London. I'm a legal practitioner and I've previously worked as a visiting professional at the ICC. I'm currently the Vice Chair of the Uganda Law Society's Research and Publications Committee, and I've published widely in the fields of public international law, human rights, and transitional justice. I am joined by one discussant and the peer commentator. The discussant for today's session is Dr. Aili Tripp. Dr. Tripp is Vilas Research Professor of Political Science at the University of Wisconsin-Madison in the United States of America. Tripp's research has focused on gender, women and politics, and women's movements in Africa, transnational feminism, African politics, with particular reference to Uganda and Tanzania, autocracies in Africa, and on the informal economy in Africa. Dr. Tripp has written numerous books and articles on areas including but not limited to women's rights and Arab autocracies, and has been the recipient of numerous awards and honors, including the Axel Springer Prize from the American Academy in Berlin, African Politics Conference Group Best Book on African Politics Award, and the Victoria Shark Award of the American Political Science Association for the Best Book on Women and Politics. In 2014, she won the African Studies Association Public Service Award. She's presently working on a project on women's political leadership in African autocracies, and a second project on women's political citizenship and conflict globally. The peer commentator for today's session is Dels Mugabe. Mr. Mugabe is a PhD candidate at the School of Law, Queen Mary University of London. He holds an LLM in tax law with distinction from Queen Mary University of London. He's an advocate of the High Court of Uganda with a deep and broad understanding of Uganda's legal system. Before returning to Queen Mary for his PhD studies, Mr. Mugabe acted as a tax partner and head of the tax department at H&G Advocates, a leading firm in Uganda. Mr. Mugabe's practice focuses on international tax planning and advisory, transfer pricing, tax litigation, constitutional law, corporate and commercial law practice, mergers and acquisitions, banking and finance law, and civil litigation. He's been involved in some of the largest mergers and acquisitions deals in Uganda. Last but not least, our guest speaker for today's session is Gaudius Turyasingura. Mr. Turyasingura is a first-year PhD student at the School of Law, Makerere University in Uganda. Gaudius is a distinguished advocate with an exceptional track record of over 6 years in the legal field in Uganda. His expertise spans various areas of law, including constitutionalism, human rights policy and law reform, and strategic interest litigation, where he has made significant contributions to advancing human rights, the rule of law, access to justice in Uganda. As a constitutional lawyer, he has played an instrumental role in legal and policy law reforms across Uganda, demonstrating his unwavering commitment to justice. Today, Gaudius will present his project titled Analyzing the Scope and Content of Article 8A of the 1995 Constitution of the Republic of Uganda. Gaudius, you're welcome. You have 30 to 35 minutes for your presentation, and it will be followed by 5 minutes for comments or questions from both the discussant and the peer commentator. And if time permits, we will have a 15 minutes Q&A session with other attendees. The floor is now yours, Gaudius.
Thank you so much, Doctor. As already introduced, my name is Gaudius Turyasingura, and I'm an LLD student at Makerere University School of Law. To begin with, I wish to express my gratitude to be part of this session, presenting my progress as far as the PhD research is concerned. I take it to be a privilege to have the opportunity to present this work and engage with a distinguished group of scholars and experts, and I look forward to receiving valuable comments and feedback, which will ultimately assist me in refining and enhancing the analysis and contributing to the ongoing academic dialogue on constitutionalism, the promotion of human rights and good governance in Uganda. I'm working on a topic, as earlier stated, analyzing the scope and content of Article 8A of the 1995 Constitution of the Republic of Uganda, and I was motivated by the need to make a contribution on enhancing good governance in Uganda, East Africa, and in other countries, especially in the areas of ensuring compliance with the principles of national interest and common good as enshrined in our constitutional frameworks, at the same time within the regional and international laws. Article 8A of the Constitution of the Republic of Uganda provides that Uganda shall be governed based on principles of national interest and common good, enshrined in the national objectives and directive principles of state policy. Then Clause 2 provides that Parliament shall make relevant laws for purposes of giving effect to Clause 1 of this article. Now, to give a bit of the background, the Constitution of the Republic of Uganda was enacted in was promulgated in 1995 with a part that provides for the national objectives on state policy. However, we didn't have this Article 8A until 2005. It is in 2005 that we had a constitutional amendment that introduced Article 8A, which I've just read. Now, the central problem of this research revolves around the scope and content, and also to do with the justiciability of Article 8A in Uganda's constitution. When you look at this provision, it introduces critical aspects in light of the principles of national interest and common good to serve as guiding principles in the governance that are anchored on the national objectives on state policy. And it has also been said that this article incorporates the national objectives by reference. However, despite the high ideals that have been introduced by Article 8A, you find that there are serious practical challenges, especially when it comes to its application. So when you look at my research is intended to look at questions like how well can we constitutionally safeguard the principles of national interest and common good within our constitutional framework as Uganda. Then secondly, we are looking at what content can be deemed as most effective to use to ensure that we do not leave out some critical aspects that are within the concept of the national interest and common good. Then the other question is Article 8A of the 1995 Constitution of Uganda a justiciable provision in Uganda's constitutional framework? And how have the courts interpreted and enforced this provision? And also, I'm trying to look at this in light of other jurisdictions. How have when you look at other jurisdictions, how have they incorporated provisions that intend to enforce the principles of national interest and common good? And what could be the best practices that a country like Uganda can actually borrow to ensure that we have a more effective constitutional framework to that effect? Now, when you look at the gap in the wider literature, I can say that while there is substantial academic discussions around constitutional law, governance, and human rights, I have found very limited. There is limited literature on specific challenges Uganda faces regarding the implementation of the principles of national interest and common good. Most especially, there is very little literature on assessment and analysis of the justiciability. There is very little literature or none on direct analysis of the scope and content of Article 8A. Most of the existing literature basically provides theoretical underpinnings on the principles of national, on the underpinnings on the national objectives and the directive principles of state policy as enshrined under the Constitution. So you find that a gap remains in the analysis of the gaps of the content and the scope of Article 8A in respect to promoting the principles of national interest and common good as envisaged by the enactors. So this comprehensive analysis seeks to inform a constitutional reform aimed at improving the content and the scope of Article 8A to better align it with the principles of national interest and common good. And this will be done by looking at what other countries, by conducting a comparative analysis and assessing how have other countries incorporated the principles of national interest and common good within their constitutional frameworks, and what can Uganda learn from that. Now, what is the main argument of this study? This study argues that while ideals enshrined in Article 8A hold significant potential for guiding Uganda's governance towards equitable and just outcomes, the lack of a clear content and scope, legal ambiguities and political tensions hinder the realization of the ideal. Now you find that Article 8A provides for us the ideal that in all aspects relating to governance in the country, it is a requirement that the principles of national interest and common good have to be borne in mind. However, if there is no clear and unambiguous provisions to that effect, you find that we cannot have effective realization of what the legislator actually intended to have. So in light of this, I've considered several theories, 3 theories, and one of them I've looked at the legal positivism, and I'm looking at theorists like John Austin, H.L. Ehart. I'm looking at Joseph Raz and several others. And I'm looking at these because they assert that when you look at the legal positivism, for them, they assert that law has to be interpreted as posted. So my aim is to look at the provision, interpret it as it is, and assess on whether the law serves the purpose for which it was intended. And this is why, to answer this question, I am very interested, and I've been trying to look for the Hansards, because I believe the Hansards can actually inform from the historical perspective what were the intentions of this legislation. And I'm also aware that this provision was introduced in 2005 when in the same constitutional amendment that introduced the removal, the provisions that removed term limits. So it seems the discussions were not as comprehensive as would have been in respect to most of the other provisions. So most of the attention was taken to the removal of the term limits, and some of these aspects were not dealt with in depth to see on whether we can have very effective provisions. Then the second theory that I'm looking at is the natural law theory, and I'm looking at theorists like Thomas Aquinas, Aristotle, and John Finnis, and I'm looking at these ones with a human rights angle, and the fact that they suggest that just laws must promote human flourishing and the common good. Then the major theory that I'm looking at is the utilitarianism as developed by Jeremy Bentham, John Stuart Mill, and Peter Singer. Now, utilitarianism has aspects that relate to public interest and common good. And this is the theory that I'm fronting majorly for the following reasons. One, it brings in aspects of inclusivity. It applies to all individuals without discrimination, and that is what national interest and most especially common good is about. Then the aspect of public interest, it directly aligns with policies that maximize societal well-being. Then it focuses on the real world outcomes rather than legal formalism and moral subjectivity. Then I believe that this theory will enable me inform policymakers to create laws that tangibly improve their lives as required by the principles of national interest and common good. Now, in terms of methodology, I'm employing a qualitative methods. The research is majorly doctrinal, and I'm examining primary legal texts, case law, and secondary sources. I'm applying a comparative analysis where I'm studying Kenya, Ghana, Norway, and the UK. In terms of the synopsis, what I can say is I've tried to give much time to this study, so I've tried to develop all the chapters. But in terms of the chapterization, my chapter 1 looks at the introduction, background of the study, the problem statement, the objective, significance, literature review, theoretical framework, and the methodology. Chapter 2 looks at historical and contemporary context of Article 8A of the Constitution of the Republic of Uganda. Now, under this, I have tried to examine the significant changes and developments leading to the incorporation of Article 8A of the Constitution. So I've tried to trace the origins from early modern thought of pre-colonial Uganda, leading to colonial rule, and also leading to post-independence shifts. I've measured on key events like the 1900 Uganda Agreement. I've looked at the 1902 Order in Council, the 1920 Order in Council. I've looked at the 1962 Constitution. Those constitutional frameworks, I found them very critical, and assessing on how were the principles of national interest and common good incorporated within those frameworks. Then I've also come to the 1967 Constitution, and I've also ended up on the 1995 Constitution, which within the Constitutional Amendment of 2005 led to the enactment of Article 8A. Now, some of the findings within the studies that I've conducted in light of the historical and contemporary context so far, I've discovered that in the pre-1995 governance structure, there was absence of explicit legal provisions on national interest and common good. We didn't have provisions that expressly provide for the principles of national interest and common good. Then, generally, governance before 1995 in Uganda was often unstable and lacked democratic foundations. I find that one against the principles of national interest and common good, and a very critical finding in light of such a study that reads in light of governance and need to create good governance. Then I also found that pre-colonial communal governance was disrupted by colonial rule. However, when you look at the pre-colonial situations, you find critical concepts of common good, though were not expressed, they were not written, but there were those aspects of common good within the frameworks within which the different communities were operating. Now, when you look at the 1995 Constitution, it introduced the national objectives of state policy, which was the first critical aspect. Then in 2005, through the constitutional amendment of 2005, we ended up having the enactment or the provision for Article 8A to promote, to provide for the principles of national interest and common good. Those are some of the critical findings that are found so far in the literature that I've read on the historical and contemporary context of Article 8A. Then my chapter 3 is examining the legal framework on the constitutional principles of national interest and common good. Now, through this, I am looking at the international framework, narrowing it down to the regional framework, then sub-regional, then domestic. Now, under the same chapter, I'm also examining the critical court pronouncements that relate to the principle of national interest and common good. So some of the cases, because there has been this other question of justiciability on whether the article is justiciable. In the beginning, the issue used to be on whether it used to be the justiciability of the national objectives of state policy, but now the question is on whether Article 8A answers the justiciability question. There are some cases like the Center for Health, Human Rights and Development versus Attorney General. It is a 2012 case. Then there is Tinyefuza versus Attorney General. That one was relating to national objectives. It is a 1997 case. Then there is Adong versus Uganda, Uganda National Roads Authority. It has aspects relating to Article 8A. It is a 2010 case. I'm looking at all these cases. Then in terms of my chapter 4, I am looking at a comparative analysis of the scope and the content of Article 8A of the Constitution with its equivalent in other jurisdictions. I have selected Kenya due to its shared historical, cultural, and legal background with Uganda to see how does its constitutional framework and related legislation align with the principle. Actually, first of all, how do they incorporate and at the same time align with the principles of national interest and common good. The second jurisdiction I'm looking at is Ghana. First of all, Uganda being in the East Africa, I'm looking at another region. So I'm considering Ghana because it is in the West, is in West Africa. With a viewpoint, Ghana in its constitution, it incorporates the national objectives as a separate chapter within its constitution. I find that a very good perspective to consider, to analyze. Would it have been good for Uganda to provide for the national objectives as a chapter within its constitutional framework, instead of it leaving it within an introductory part of the Constitution? I find that very good, and something that I intend to analyze in detail and see if there are some best practices that I can borrow from Ghana. Then South Africa was chosen based on the fact that it has that global recognition and it has that rights-based constitution, and it has had a lot of judicial interpretations that relate to constitutionalism. So I need to borrow those perspectives that relate to aspects on national interest and common good. I am also interested in Norway because Norway represents very many aspects that relate to national interest and common good, especially based on its stable democratic system with strong commitments on aspects of accountability, human rights, and constitutionalism. I find it a very good jurisdiction to consider for this study. Then the United Kingdom, most of Uganda's laws are borrowed laws. They are copy and paste laws. So I intend to contrast our constitutional framework with the unwritten framework of UK, and trying to see UK has a framework that has influenced frameworks of most Commonwealth jurisdictions. So I intend to assess how does its constitutional framework, in quotes, though most of it is said to be unwritten, how is it incorporated, if so, and if not, what is there to relate to the principles of national interest and common good, and what are those aspects that a country like Uganda can borrow to better its governance structures. Now, through this reading of the literature and the findings, I've been able to think through on what could be some of the key recommendations that I will make out of this study, because as you're reading, you find that, oh, this is something that relates so much, I think I can consider this aspect. So I have in draft a bit of recommendations, and one of them is I find that there is need for urgent review and a redraft of Chapter 2 of the Constitution to eliminate ambiguity in Article 8A. And I'm thinking that if it is not a redraft, there might be need to integrate the national objectives and directive principles of state policy into Chapter 2 to ensure justiciability. So I believe that with that would be an answered question. And before I forget, the intention of my study is to inform a constitutional reform process in light of that specific article, Article 8A. And at the end of the study, if my recommendation is a redrafting, I intend to redraft those particular provisions. The second one is Parliament must urgently fulfill its constitutional obligation. When you look at Article 8A, Clause 2, it states that Parliament shall make relevant laws for purposes of giving full effect to Clause 1 of this article. And I can state clearly that from my research, I have not found a specific legislation enacted by Parliament to give effect to Article 8A as required by Clause 2 of Article 8A. So, if this is I'm going to give it as a recommendation, but if it is not taken in by Parliament, failure to act with will prompt a public interest litigation case, most likely from myself, before the Constitutional Court through the provisions of Article 137 of the Constitution, seeking orders to compel Parliament to enact requisite laws within 6 months. The petition will seek declarations of constitutional violations, mandatory legislative action, and I believe that this judicial intervention is necessary to uphold constitutional supremacy and good governance, because the Parliament must enact immediately to prevent the national objectives from remaining mere aspirations. We should see national objectives and the principles of national interest and common good be realized. From Kenya in its constitution, it has a chapter on ethics and national values. I have looked at Uganda's policy of 2013 on national values, but I find the principle of national interest and common good relating so greatly to national values. I find that borrowing from Kenya and incorporating these national values within our constitutional framework would make them more relevant and provide an obligation to state and non-state actors to ensure compliance and to these guiding values. Then I'm also looking at a recommendation on having a nationwide civic education. This is to civil society organizations and government, especially institutions. There is need for a nationwide civic education, general on the Constitution, but my recommendation specifically speaks to the national objectives. As a country, what are our objectives? What falls within our national interest? Because as a country, we might be here when we don't know what our national interests. What is for the common good? What is for us as the people of Uganda? I believe those are very critical aspects that can lead to a better governance. Then in the same vein, training for public servants. They need to know, and as they make all these decisions that concern Uganda as a country and its population, they should know what entails principles of national interest and what is for the common good for the people of Uganda. Then when I was looking at the US, I found that in the US there is a private institution which is a commission on national interest. I'm considering a recommendation. I'm aware that there is a lot of rationalization. They have been trying to reduce the number of government entities. That is in pursuit of reducing the rate of the cost of public administration. But I find a commission on Uganda's national interest that relates to Uganda's national interest a very critical commission. And I intend to model this from what I found in the US, and my recommendation would be this commission has to be created statutorily, if not constitutionally. And the functions of this commission would be to assess compliance with the principle of national interest and common good in both domestic and foreign policies. Then secondly, would require reports from this commission on whether Uganda is still on the right track in as far as the implementation and the journey to the realization of the principles of national interest and common good. Then my other proposal in line with that commission would be, it has to be composed of representatives from various sectors, because not only one sector can tell us what is for the common good, but on the composition, I'm still trying to define what are those sectors. Then I believe that this commission would ensure strict monitoring and enforcement mechanisms for national interest and common good. So at the end of it all, my intention is to come up with a bill, provide an answer to what Parliament would have done in respect to Article 8A2, because there is a constitutional requirement that Parliament must enact a law to bring into force the provision, Article 8A1, which law is non-existent. Then, if Parliament does not take up the bill, my intention is to bring a constitutional petition in form of a public interest litigation to the Constitutional Court of Uganda. So my intention is to bring a constitutional petition to ensure that we take up the judicial parameters to require Parliament to do its job. I think in short, that is what I'm looking at. My work is generally work in progress, as I had stated, but what I can say is I'm really very interested in aspects to do with governance, constitutionalism, and specifically aspects relating to the principle of national interest and common good, because I'm interested in knowing what is that is in the interests of Ugandans. What is it that is for the common good? I believe that at times decisions are taken by individuals based on their own understanding without a clear guiding framework, and that is the framework that I believe should be provided for constitutionally and must be followed by whoever holds a public office. That is it. I wish to once again appreciate you for inviting me and for listening to me. Thank you so much.
Thank you very much. So now we shall use 5 minutes to hear from the discussant, and then after that we shall also hear from the peer commentator, and hopefully we should open it up. So Dr. Tripp, over to you.
Okay, so yeah, thank you very much for a really thought-provoking presentation, and thank you also to the organizers for inviting me to make some comments on this presentation. What I thought I would do is just carve out a little, because national interest is many things that would fall into that bucket. So I'm just going to talk primarily about issues that have to do with economic, social, and cultural rights. And so I'm just going to throw out some questions there, and it won't be possible to answer all of them, but maybe they'll be helpful in terms of thinking about the broader project, which I think is very, really important, very exciting, and just, very, very consequential. In August 2020, the Constitutional Court of Uganda handed down a landmark judgment for maternal health rights in Uganda. And this has made actually a significant contribution to the growing jurisprudence around maternal health, not just in Uganda, but elsewhere. And so I'm wondering, what would be some of the lessons from this, because this is an application of this Article 8A. Can we learn, what can we learn from this the constitutional petition number 16 for other areas, and how would you evaluate that and its success? I mean, it seems just on the surface that already the rates of maternal deaths have gone down since that time in the last few years, and so there's obviously been more focus and attention paid to the issue of maternal death. But are there other areas that maybe work better than others for this kind of review of Article 8A? That would be another question that I have. Are there areas that one can apply it more easily than others? One of the things that I've also wondered was, what are the consequences for the state? Because we're not talking about really individuals here, we're talking about the state. What if the state doesn't comply with these, with the national objectives? How enforceable are these, would these provisions be? Another question that's been asked about the application of these kind of national interest objectives has to do with whether or not the judiciary is overstepping its role and moving into the domain of the legislature, for example. Is there a danger of overstepping the role of the courts in making decisions that have been the purview of the legislature, of the parliament? Are there issues in which, I mean, some people have raised concerns that maybe the judiciary is not equipped to make budgetary kind of decisions, and maybe it's better for the left to the people who are experts in this area to make technical decisions and budgetary decisions. So are there policy choices that that are better left to others, or can the judiciary have a bird's eye view of the policy making process? In other words, what's the competence of the courts? To what extent is Article 8A aspirational? To what extent was it introduced for purposes of status signaling? And I guess the more practical question is that even if the parliament, as you suggest, parliament should be passing laws, what if they're not enforced? I mean, because you can have these grand ideas about, national interest, but then, and the common good, but in a resource-poor country, sometimes it's not easy to actually live up to, even if one has good intention. It's hard to always live up to those aspirations. And so to what extent should we see this as something that really can be enforced and applied, and to what extent? I mean, I think it was in the case of the maternal death case, but, again, it's a broader question in other areas. The debate around this whole issue, at least for the economic, social, and cultural rights, has kind of shifted from kind of traditional concerns about whether or not these kinds of rights should be subject to judicial adjudication, but now the question really is more the extent to which the judiciary should be empowered to intervene. And so, again, are there limits to this constitutionalization of national interest? Are there, where do you put the boundaries? How far can one go? What is the, and perhaps other areas that are easier to adjudicate than others? So that's another part of the question. In your project, you're looking at Norway and UK, but as well as Kenya and Ghana. But I'm just wondering, can one apply lessons from Norway, that's one of the richest countries in the world, to Uganda? I mean, are they how transferable are those lessons, and how applicable would they be? So, and then I think maybe you've carved out a huge terrain for yourself for this. It's a very ambitious project, and maybe rightly so. But I'm just wondering, are there areas that are where you could make recommendations for more specific reforms, and other areas that are maybe that you would leave outside? In other words, what are the parameters of your project in terms of what's feasible in a thesis, I guess, and also what might be some of the limits of realizing some of the ambitions that you've laid out. I mean, I love the policy recommendations here, but how realistic are they, I guess, and what's doable and what's less doable. So I'll leave it at that. Those are my 5 minutes, and I'll turn the floor over to Deos Mugabe.
Thank you very much, Gaudius, for the presentation. And yes, this most ambitious of projects. And listening to you, I must say I'm surprised at the abilities that you have. Now, starting with where Tripp ended, the comparative analysis, and the fact that you are going to be combing national interests of 1, 2, 3, 4, 5 countries. That's ambitious, but hopefully you can do it. But I also had an immediate, when you mentioned Norway and the United Kingdom, I immediately wondered how your findings in those jurisdictions could be transferred to a country with limited resources like Uganda. If one other thing I think that needs to come out more crisply, that I didn't get very well, was the problem statement. I from what I gathered is that this study argues that the lack of clear content and the scope of Article 8A are problematic in as far as governance is concerned. But I think it needs to come out very clearly and tell someone what is the problem here. I failed to I couldn't hear the exact problem. I understood it, especially when you listed them, I think, in 3 sub questions, but I think the problem itself needs to be very crisp, because if you do that, I think it would answer my next question, which relates to when you look at Article 8.2, the last time I checked it, which is a long time, it seemed to suggest that Parliament should pass laws, not particularly one, but laws that at the end of the day will lead to the realization of the national interest and the principles and objectives that are stated there. And so when you look, for example, at objective number 26 and 27, 26 is on accountability. 27, I think, is on the environment. When you look at them, and then Uganda enacted the Leadership Code Act. Can we say Parliament, by enacting the Leadership Code Act, really acted in accordance with Article 8A2? Can we say, when we look at the national petroleum laws, oil and gas laws that we have in the current regime, do they address some of your challenges? Or am I having this all wrong? And that the conclusion should be that we should have one act of Parliament that spells out the national interest. I think I didn't get it, because I think we have about 29 objectives that are stated in that part. And I think my initial understanding, and I might be very wrong now that you talk about it, is that whenever we have Parliament passing laws, it must, as a first point, make sure that these laws are consistent with national interest and objectives of that we seek to pursue. And therefore, many laws that are being passed on an ongoing basis should be placed somewhere. So the revenue laws, the public finance laws that are being passed, therefore, should be looked at in the sense that we're trying to achieve some level of economic independence, if I should use the word. So could that be the sense in which, a lens in which maybe someone could look at this problem? And of course, that doesn't take away the problem that even the laws that have been passed, you could argue, are not in our interest at all, not at all. But could it be a particular lens that maybe could be explored to buttress the argument, one, that Parliament needs to be more serious about the 29 interests that are stated in that part of the Constitution. My final comment, I don't know if I have any minute, but I had another thing that, of course, I found legendary and consistent with Gaudius, the theoretical framework. I noted you are going to use, I don't know if you said you're going to use or if you're going to consider, but positivism, and then the natural law scholars. In my experience, usually when you put these two theories, if you put these two people in one room, they will get out with a bloody nose. They won't come out healthy. Thank you very much, Dr. Norman, for the invite, Dr. Kirabira for the invite, Tripp for the good comments. I reiterate everything Tripp said, and that is my very humble contribution. But the project is very, very, very good, and hope to read all the publications that come along with it.
Thank you, Mr. Mugabe. Over to you, Mr. Turyasingura.
Yes, thank you so much for the comments. I think what I can say is I take all of them in good faith. They trigger the mind more. And what I can say is I'm going to look at all the aspects that have been given by Dr. Tripp and Deus. I've been taking note of all of them, and I'm going to consider all of them. Aspects relating to Article 8A that come from the maternal rights case. It is a very critical case, and it discussed aspects relating to Article 8A. From my analysis, current aspects of the judiciary overstepping and taking up the role of Parliament. We have a very recent case of Attorney General versus Kabazuguruka. It is going to be within my chapter that will, my part of the work that will discuss judicial interpretations and judicial pronouncements. Then I find it a very good comment to ask on whether the natural school of thought can sit in the same room with positivism. I shall reflect more on that and see if I can choose one and maybe substitute with another. I find it a very good question. Norway and UK. Norway and UK. The rationale, because I'm wondering if you can learn. I feel it is good to learn from the person who is doing better. You cannot learn from. You cannot learn from people. Okay, if you have 5 people to learn from, you cannot choose to learn from all the people that are doing the way you're doing. So you can check out on them and see how are these ones that are close to within whom we are in the same category, how are they doing it? Are there some aspects that they are doing better than myself? And then you also go for those that are doing better than you, and that is where you expect to pick most lessons from. Because when you look at the goals of this project, the principle of national interest and common good, they are very broad, and you cannot assess their success within 1 year or 2 years. They have that inspirational bit, but they have to be progressively implemented. In everything that you do, you have to incorporate aspects relating to national interest and common good. And the future will tell on whether we shall reach the stage where Norway and UK are now or will be in the future. I think generally that is it. I wish to appreciate so greatly the comments that have been given. I've taken note. I'm more inspired to do more reading in relation to this and think about my work more, because it is through the reflections that you keep on refining the aspects relating to this work. New literature tilts the mind and you adjust on some of the aspects. But what I can say is I look forward to making this critical contribution in light of the principles of national interest and common good, and if possible on how to readjust and redraft the 1995 Constitution, or if not, on how to make its provisions implementable as envisaged by the promulgators of those provisions. Thank you.
Thank you very much. Maybe one quick comment or question from the audience. Otherwise we'll close this off. So thank you very much, Gaudius, for an insightful presentation. It highlighted key issues related to the 1995 Constitution of Uganda. Many thanks to Dr. Aili and Dels for the useful comments, and to everyone that has attended this session. The Global South Network warmly welcomes PhD students from any discipline and any part of the world to share their projects and receive interdisciplinary feedback. Anyone interested in presenting their work or participating in a session can kindly contact Dr. Nauman Rayat, the founder and the convener of the Global South Network, at the email address that is provided in the chat box. Same time next week, let's meet our next guest speaker, and that is going to be Yinchen Zhang, a PhD candidate at the School of Law, University of Liverpool, who will deliver the session titled Exploring the UK's Text and Data Management Exceptions, Harmonization or Competition in the Context of Generative AI, which is going to be on the 26th of February, 2025 at 3 to 4 p.m. UK time. Take care, look after yourselves for now, and have a wonderful day.
Thank you very
Bye.
much. Bye-bye.
Bye.
Okay, thank you so much. Bye.
Bye. Thank you.